and the impact on children. This has been one of our most hotly requested topics, and thank you so much for taking the time to join us either in person or online. We're really lucky today. We have an awesome panel to come and chat with you. We have Wendy Wayne, who's the Director of Immigration Impact Unit on the Committee for Public Counsel Services, Sarah Gibbons, who's the Senior Director of CHNO here at Boston Children's Hospital, and Kelly Hayes, who's the Associate General Counsel, also here at Boston Children's Hospital. So we are going to let them go ahead and present. If you have a question, please write it down on the index card that you were provided when you walk in, and see either Sarah, Rachel or Claire.
Who's out there?
We'll just go with Rachel. Hold up your card and we're going to collect them. We're going to answer them at the end. Folks online, definitely feel free to type it into the chat box. We'll make sure to get it to you as well. And without further ado, I'm going to bring up Wendy to kick us off. So Wendy, yeah. Just a slide.
Okay, I don't have any slides, so I just leave it on.
You can just leave it on.
Okay, great. Okay, that's great. Hi, everyone. Thanks for having me here. I was just saying to the other panelists that I'm not sure if I should be going first or last, because this is the more restrictive part of the presentation and the sort of probably more depressing part of the presentation, but I'm kind of used to presenting on that since I do immigration work. I work for the State Public Defender's Office as an immigration specialist, mostly on the intersection between immigration and criminal law, but also do a lot of training of attorneys on sort of the intersection of state and federal immigration law and some litigation and advice on individual cases. So, you know, the bottom line, I'm going to talk for about 10, 15 minutes just about non-citizens, so non-US citizens. That includes people with green cards. When I say non-citizens, I mean anyone who's not a US citizen. Even though, you know, the bottom line is that even though marijuana use is legal for personal use, and there are new laws on legalization of marijuana and medical marijuana under state law, immigration law is federal law, and it continues to be controlled by federal law, and that has not changed in reaction to the legalization of marijuana in Massachusetts or in other states. Also, just as a side note, even though marijuana has been legalized for personal use, for medical marijuana, OUI, operating under the influence of marijuana, remains a criminal offense, just as a FYI. So under federal immigration law, drug offenses can cause the most severe immigration consequences for non-citizens. And legalization of marijuana in many ways presents sort of a red herring for immigrants, because under state law, it sounds like the laws have been relaxed a lot, and yet for non-citizens, the same federal immigration law and the same restrictions to non-US citizens apply, regardless of the changes in state law. So it is still a federal crime to possess marijuana. There's no exception for medical use, and that can include even using it in your own home for for medical purposes. We have heard that in some states, ICE is seeking out non-citizens who have been using marijuana legally under their state laws. Fortunately, this is not happening yet in Massachusetts. I'm hopeful it's not going to happen in Massachusetts, but it's really hard with this administration and the aggressive nature of immigration enforcement over the last year to really never say never. Attorney General Sessions has encouraged and given permission to federally prosecute for marijuana possession, to go after states, residents of states where marijuana use is legal. We've heard that Customs and Border Patrol are questioning people about marijuana use as they're entering the U.S. This is non-citizens entering the U.S. One thing that does concern me, although I repeat, we have not seen any enforcement for legal marijuana use, any immigration enforcement against people who for using marijuana legally under state law in Massachusetts. We have not seen that yet. One thing that does worry me, though, is that Massachusetts is considered a sanctuary jurisdiction by ICE. And because of a few different reasons, one being a recent decision by our state Supreme Court finding that it's unlawful to hold people on immigration detainers. And so there has been more aggressive immigration enforcement in Massachusetts than there have been in some other jurisdictions. So whether this will be included in that in the future, it's really hard to say, but we've heard no rumors about anything. In fact, when I was first asked to join this panel, somebody said, what's happening in Massachusetts on this issue? I said, nothing as far as we know. And still nothing as far as we know. So just to give you an idea about the consequences that marijuana use can have for non-citizens. It can make an individual, again, who's not a US citizen, so not just somebody who does not have lawful status, but we're talking about green card holders too. And in Massachusetts especially, there's a relatively large population of green card holders, people who have been here lawfully for a long time. Some of them may even think they're US citizens, but they're not. They got green cards a long time ago. A conviction for possession of a controlled substance is a deportable crime. So if you're convicted of criminal possession of marijuana, however, there is an exception for first offense possession of 30 grams or less of marijuana. So it is not likely in Massachusetts now, people with old marijuana criminal convictions could be subject to deportation, but under the current law, it's not illegal to possess 30 grams or less of marijuana for personal use. So somebody would not be criminally charged. So on that sort of ground of deportability, that legalization has changed that and made that better for non-citizens. There's another ground which we have not seen used in this state and really not much around the country because there's so many grounds of deportation. There's so many ways to make somebody, for criminal offenses, to make someone deportable or inadmissible, that there are certain grounds that we just haven't seen used that much because they don't need them because there's so much else to choose from. But there is a ground of deportation called drug abuse, being a drug abuser. You can be deported for being a drug abuser. It applies anytime since your admission into the US. I've never seen this used. I don't know other people who have seen this used. There are no standards for it, so it's really hard to advise somebody on that. But people, non-citizens, should be aware of that. As far as inadmissibility, you have to be admissible under immigration law, not only if you're trying to enter the United States at a border or an airport, but you also have to be admissible if you are here and you're applying for a green card. So admissibility, the grounds of inadmissibility apply to people who are physically here and applying for lawful status. Conviction of possession of a controlled substance or even of marijuana makes you inadmissible. There is a waiver available for 30 grams or less of marijuana. So again, that one is probably sort of cured by the legalization of marijuana. However, you don't have to have a conviction. You can admit to the elements of the offense. And there's this whole body of case law about how somebody can be found to not be admissible to the US based on admitting to the elements of a crime, even if they weren't charged with the crime and they weren't convicted of the crime. And because possession of marijuana for personal use is still a federal crime, that raises some concerns. So it is possible that a client's statements could be used against them if they admit to an immigration officer that they have used marijuana. And we have heard again that at least in some states, Customs and Border Patrol agents are questioning people rather vigorously at the border about marijuana use. Reason to believe someone's a drug trafficker is another ground of inadmissibility. And then there's also this sort of mushy ground, which is used occasionally, being a drug abuser or a drug addict. So if somebody if somebody cannot prove that they are not they have not abused drugs within the last year, if they can't prove the negative, then they are inadmissible. That is a ground of inadmissibility that is used more often. That could limit someone's ability to get a green card. Also, a finding of good moral character, which is required for citizenship. It's also required for certain forms of relief from deportation that they're may be eligible for if they are here without lawful status, but they've been here a long time. So a lot of people, for example, who are, Massachusetts is a pretty large Salvadoran population. A lot of those people have been here for 15, 20 years with temporary lawful status, which is going to expire. Some of those people, if they were arrested by ICE and placed in deportation proceedings, might have a defense for deportation.
Ask them to mute their lines. Those
We're
words.
just gonna
Okay, so the advice to clients is any non-citizen clients, and this includes juveniles. And for juveniles, you know, it's different, and the laws are even a little mushier. They're not, if they're convicted of a crime, it's not a crime, it's a juvenile offense. On the other hand, it's not legal for personal use for kids under 21. The analysis as to the risk gets even more complicated. Basically, the most important thing for non-citizen clients is do not admit marijuana use to any immigration official. If anybody asks you any questions about, you use marijuana, do you like marijuana, do you have marijuana in your house, is that a joint on the floor of your car, you do not have to, you need to tell clients they do not have to answer the questions. They should not answer the questions. And if anybody has any evidence of marijuana use, medical marijuana use, personal, anything in their history, they should not be applying for any immigration benefit without the assistance of a lawyer. They should not be applying for a green card themselves, because there are going to be questions on the form that are going to be tricky. Somebody with experience needs to help them figure out how to answer those questions, because you can't lie. And so what exactly is the question asking? How do you answer it? Weigh the benefits and the risks of applying for this immigration benefit like a green card. Actually, that's about it. So just know that, you know, the most important thing is not to admit any use. For non-citizens, unfortunately, marijuana use is, for medical purposes, personal purposes, is really, really risky. It's just as risky as it was before legalization. There are some flyers available, materials in the back, which I really suggest if you work with any non-citizen clients, especially the one-page flyer that was prepared by this great organization in California, you should give that to your clients. And you can print it out. It's available in other languages on their website, probably 3 or 4 different languages.
Thank you so much, Wendy. And if anyone's interested in the flyer that Wendy is talking about, there are copies outside. I'm also going to be sending up a follow-up email that's going to include the link with all the languages. So next up, I'm going to invite Joe. Yeah, okay.
So that would make more sense.
Yeah, that's totally fine. We're flexible. Okay, there you go.
Hi everyone, I'm Kelly Haynes from the Office of General Counsel here at Children's. And this is kind of a lot of information to cover, so I'm just going to sort of speed round it for you. Our learning objectives today are to discuss the legal risks for providers and hospitals relating to medical marijuana, cover the legal landscape, kind of a high overview of the federal and state laws, the difference between recommending and certifying versus prescribing, what would constitute aiding and abetting under the federal laws, the consequences if you are found guilty under the federal laws for either prescribing or aiding and abetting, and the likelihood of prosecution given today's political climate, and how to stay safe. So the legal landscape on prescribing, I'm just going to start from high up. The Supremacy Clause of the U.S. Constitution says that the federal law always supersedes state law, meaning if there's a conflict between the two, the federal law always wins. So under the authority of the Federal Controlled Substances Act, the DEA issues registration numbers to providers who are authorized to write prescriptions. They can write prescriptions for Schedules 2, 3, and 4 drugs only. You can't write a prescription for Schedule 1 drug, and cannabis and any cannabinoid products, including low THC variety products, are Schedule 1. Schedule 1, according to the DEA, are drugs that are highly addictive and have no medical value. In that pile are marijuana, heroin, ecstasy, and LSD. And a little side note here, in my theory on why they don't have any proof that that marijuana isn't highly addictive and is of no medical value is, and this is my theory, I'm not sure if it's absolutely true, but since marijuana is illegal, it's hard to get federal grant monies to do any kind of studies to figure out whether it has medical value or if it's highly addictive. Okay, so there's a distinction between recommending and prescribing. So recommending the use of medical marijuana is okay under the First Amendment, and there's a case called Conant v. Waters, which was heard in 2002 and which still stands today. It says that the recommending is an opinion, and opinions are protected under the First Amendment. The court found this is true even though it's reasonably foreseeable that a recommendation is going to be used to obtain the cannabis or cannabinoid products. Also, certifying a patient that has a qualifying medical condition and could benefit from medical marijuana is also permissible. But you cross over into the line, across the line of aiding and abetting when you make a recommendation about what products exactly you want that patient to have, like whether it's extracts or edibles or whatever it is. If you make a recommendation about the strain that they should get or how many milligrams or whatever the dosage is, that's when you start crossing over and you could be prosecuted. So federal law says it's a criminal offense to aid and abet purchase, cultivation, or possession of cannabis, or to engage in a conspiracy to cultivate, distribute, or possess it. So they look at a prescription as an order to a patient to consume a controlled substance, and the aiding and abetting part comes onto after this and, in order to the pharmacy to prepare and distribute the controlled substance. So it's tricky. So the consequences for providers are that your DEA registration can be revoked. You could, there could be fines for each prescription you've written. There can be prison time associated with each prescription. Any state that requires a provider to prescribe cannabis or those products could expose the provider to the loss of their DEA license and to criminal liability. So you have to keep in mind that Massachusetts wasn't wearing a hat thinking we're protecting providers. They're just saying medical marijuana is legal here. And so is other recreational marijuana. But they weren't analyzing whether or not that requiring a provider to write the prescription was going to put them at risk. That's for the providers to analyze. I already covered that. Consequences for hospitals are CMS. We can lose our deemed status, which means they wouldn't give us any more money. We could lose all our federal monies, including residency program money, research, Medicare, Medicaid, any of those reimbursements. I mean, that's the sky is falling sort of worst case scenario. So what's the likelihood of this happening? The former administration issued what's called the Cole Memorandum. Cole was just the guy who wrote it. And it said that the state should, or the federal government should take a hands-off approach to states that legalize medical marijuana, or I think also recreational marijuana. But on January 8th of this year, the current AG revoked the Cole Memorandum and instructed federal prosecutors to use their discretion in enforcing the federal law. And then in addition, he sent a letter to Congress demanding the elimination of the Rohrabacher-Farr Amendment. And that amendment, just a zip forward here, you could see at number 6, it says, none of the funds made available to the Department of Justice should be used to implement or basically should be used to crack down on states who legalize marijuana. So he sent that letter to Congress demanding elimination of that amendment. As part of the stopgap spending bill, twice now, Congress has reaffirmed that amendment, but it's only good until March of 2018, about mid-March. And then it might be eliminated or it might stay. It depends on how well they negotiate for it. So in other words, we're not out of the woods yet. Just because it's here today, it could be gone in a couple of weeks. So how do you stay safe? Don't prescribe medical marijuana or the products. Don't administer them yourselves. Don't store them. Don't take possession of them for your patient. It's okay to recommend or certify a medical condition necessitating it, but you want to stay away from specifying dosage or the type. And hospitals, I think I eliminated my slide here on that, but hospitals can I have it combined, shouldn't store marijuana in the Pyxis machine. They shouldn't give special lockers to parents. They shouldn't have any part of it. If parents have, and I know this happens a lot with the kids who have seizure disorder, parents are already giving different tinctures and low THC products for that. What we're saying is that parents have to maintain control of that and they would administer it themselves. But I'm gonna let Sarah get more into like how we're operationalizing it because I'm gonna tread into her territory. I think these slides will be available so you can, there's clickable links in here for anybody who wants to look those over.
All right.
All right.
Thanks so much.
Thank you.
So just a quick thing before, and remember, if you have a question, to hold it up, we'll come around and collect them. Folks in the back, there are seats in the front. We're pretty cool up in the front too, so definitely feel free to grab a seat. And I am back through this. Okay. And Sarah, we are good to go. Great.
All right. Hi, everybody. So I'm going to talk to you actually about, now that you've heard about the legal landscape, about what we as an institution decided to do as a hospital policy around medical marijuana and related products. So I'm speaking here on behalf of many of my colleagues in nursing and in pharmacy, the prescriber community, as well as the Office of General Counsel, who we all worked very closely together to come up with a policy that was workable for our staff, but also supported our patients and families. So as you can imagine, with the legalization of marijuana in this state, but also in other states, we have had an increasing demand by our patients and their families for the ability to continue the use of medical marijuana while they're in the hospital. And with that came a request from our staff, how do we work with these patients and families? How do we handle or not handle these products? Do we order them? Do we not order them? And so over the past several years, we have been working together to try to create something that is both within the bounds of legal for our hospital, but also supporting our patients and families. And we had some unfortunate timing with our rolling out of our policy and our web-based education around this, because we actually sent it out to staff on January 8th. At the very same time that AG Sessions said, hold on a second. So you can imagine that we were a little nervous at that point, but we decided to move forward anyway. So increasing demand from patients and families, requests from our staff to support them. So what did we do? And you'll note that this is in SBAR format, because that's how I do everything. I can't function not in SBAR, for those of you that know me. So the background, as Kelly discussed, is that the federal government considers marijuana to be illegal. However, Massachusetts has laws that now permit it, notwithstanding the sort of slowdown that's happened in the past several days. These laws are in opposition to each other, so we're sort of between a rock and a hard place. So what we decided was that as a hospital, we should mitigate our risk of sort of butting heads with the federal government by refraining from ourselves administering and storing marijuana or any cannabinoid, I cannot say that word, for patients. But we still want to support them. So what we decided to do was put into place some guidelines for staff where they could allow patients to continue to use their marijuana, but not involve our staff in that. So what did we do? Our staff were very concerned that they didn't want to be handling any marijuana products. They didn't want to be ordering marijuana, but they also didn't want the patient to start getting other medications that could potentially interact with marijuana. We know our pharmacy colleagues were very concerned that they wanted to know that a patient was getting marijuana. As they were checking medications, it's their duty to ensure that there's no drug interactions occurring. So they were very concerned that they wouldn't know that a patient was on marijuana and they didn't feel like they could appropriately assess the medications that the patient was on. So we had to tackle that piece of things. So the question became, do we allow providers to order it? Do we not allow them to order it? We don't want the prescribers to be prescribing marijuana, but we want the staff to know that they're getting it. So what we came up with was, in our electronic health record, we have the ability to order something called home supply. And that could be anything that we don't carry on our formulary. So our formulary is our drug database of all of the medications that we carry in the hospital and we allow patients to be on. Because marijuana is not something that we obviously have in our pharmacy, we didn't have an orderable for that. So what they decided to do is use the home supply order and put in that it was for medical marijuana. So then the pharmacist would have transparency to that, and they could actually perform drug-drug interaction checking to ensure that whatever other medications the patient was on were not gonna interact, and they could have conversations with prescribers if that was the concern. The other thing that we wanted people to do was have a thoughtful discussion with the patient and family, as appropriate, about the continued use of medical marijuana while in the hospital. These patients are obviously being admitted for some reason. Maybe they're sicker. In the case of a neurology patient, maybe their seizures are getting worse. The team wanted to be able to have a conversation with the patient and family about whether the marijuana could be contributing to that and decide whether they should continue with it or not. And if they decided as a group that the risks of stopping the marijuana therapy outweighed the benefits of stopping, then they would document in their note that that's what they felt, and then they would write the order. The other things that we made clear to our staff were that they could not label it, they could not store it, they could not administer the marijuana or any of the related products, and that this should not be brought to the pharmacy for evaluation. One of our practices is if a patient has a medication from home that they're going to continue to give because we don't have it for whatever reason, the pharmacy will actually do an evaluation of that medication. They'll label it so that we sort of keep track of it in our system. We said that is not something we want to do with the marijuana, not bring it to the pharmacy, families to maintain control of it. So the other thing that we did was we did a lot of guidelines for families as well, because if we're saying we're not going to take control of this medication, we're not going to be the ones administering it, we need to give them some guidance as well. So what we said is that the family member or the guardian has to store the medical marijuana products away from the child and potentially any roommates that are in the room with them at all times. They have to keep it in their possession. They can't leave it around. They're also required to administer all of the doses. Our nursing staff, we said, are not allowed to administer any doses. And so if the family was absent for any reason, the patient would miss a dose. Then the staff would never in any circumstance do the administration. And we did run into some concerns from staff that if a patient had a new tube, a new gastrostomy tube or a new nasogastric tube, a way that we would be giving medications, that this could pose a problem, because normally with a new tube like that, the staff does all of the medication administrations and then does teaching with the family. But in these cases, if they got a new tube, the family had to be immediately ready to start using that tube to give those medications. So it involves some thinking about how we're going to quickly educate those families if needed to be able to give those medications. In addition, the nurses wanted to be able to chart that the family was or was not giving the doses so that the team could have a full picture of what was going on. Because if, in the case again of a seizure patient, if the seizure started getting worse, they wanted to be able to see, oh, mom was actually gone for 12 hours and the patient didn't get 2 of their doses. So the order, as part of the order for home supply, included a frequency at which the patient was getting medication, so that the nurse could document that the family gave it or didn't give it, and they could see a full picture. And then the other thing that we put in, which probably should be obvious to people, patients, families, but as new ways to use marijuana come about, people try to bring them into the hospital. So we had to make clear to our patients and families and staff actually that that vaporizing or any sort of non-sort of edible or liquid could not be brought into the hospital. There would be nothing that could cause smoke in the institution to be allowed. And so we had to put that in our policies and our family education as well, so that people were aware. So that is really how, that's it for me. So that's really how we approached our policy for the hospital. And we did Released education, as I mentioned, on January 8th for nursing and pharmacy staff. We also released education for our prescriber community a little while later. And then we did a communication blitz as well for staff about that, so that people were aware of these new policies and practices, I think, a few days later as well. So we did as much sort of education and communication as we could.
Great, thank you. All right, yeah. That was super helpful. So we have lots of time for questions, and I saw a bunch of you writing down furiously. So I'm gonna kick it off with the first question, and for folks online, if you have questions, definitely feel free to just type them into the chat box. But our first question, I think, is for Wendy, and it says, we talk often to our patients about marijuana and other substance use and document and bill for substance use issues. Are there any circumstances under which law or immigration officials can access the medical records and the billing information and see this? I apologize, we don't have handheld mics right now, so.
I don't know what to say, so.
Good luck with that.
This is a tough question. I think not. I think it is okay. I mean, I would not, I'm certainly not in a position to say that people should be, that medical staff should be documenting things differently or omitting things that they would normally include. I'm just trying to think through some of the scenarios that if there's an allegation that somebody is a drug abuser and they need to show they're not, they would normally just get an exam from a medical professional who does these sort of immigration health exams. If these records contained evidence of marijuana use, then they would not be using them because they would not be helpful. So as I'm sort of going through the different ways that marijuana use, causes immigration consequences, the two are really the inadmissibility and deportability for drug addiction or drug abuse. And those, somebody has to ICE doesn't have the right to get these medical records yet. No, they don't. So I think that it is, if it's medically necessary or, best practice to include that information, people should continue including that information in medical records. So that's not something that immigration officials are going to see unless the patient decides to disclose that, which if a patient has ever used marijuana, should not be talking to or showing any documents to an immigration official without the advice of an attorney who would then advise that person do not use these medical records.
Cool. We actually do have a handheld mic now, so we can do questions. So if you have a question, definitely feel free to raise your hand, and folks online definitely type it into the chat box. Cool, so you're all 100% clear on how marijuana works.
Is it on?
It is on.
Yep.
Mostly for Kelly, is there any risk for prescribers that their names are tied to these home supply orders while the patients are in the hospital?
And Kelly, I'm going to answer over here. Apologize, we only have one mic. Can you just repeat?
So the question is whether there's any risk for the provider if their name is tied to a home supply order. I think the question could be asked by law enforcement, but we would have a response to say, this is purely for documentation. It's not an order in the sense that they're ordering the patient to take it or ordering the pharmacy to produce it or ordering nurses to give it. It's just in there as a placeholder, if you will, and a way for people to document that this was administered by the family. And we would also do an argument weighing the risks and benefits of not documenting it at all and risking drug interactions, which is a safety problem for the patient. It's just bad medical care. And we would talk about the relative risks of making the patient just go cold turkey, which is another thing. Just like, okay, well, no, you can't bring it in the hospital at all. then we run into problems with parents sneaking it in and we don't know where that's happening and we're administering other meds and we don't have a full appreciation of maybe how sedated the patient could become or that kind of thing. So that's how we would approach it. It's never happened yet, so we don't know for sure, but I think that's probably the first way we would go about it.
Question up here. I don't know
I
if you
can-
need a mic.
Well, I don't know if folks will hear, but you can, Kelly, you can stay where you are. So the question, and this may be, all of you may have comments about this, but there are a lot of issues that come up related to child protective concerns of parents giving kids a medication that may or may not be right, that may or may not be prescribed, and in other situations, if a family member was giving a medication that maybe wasn't prescribed to a child, we might have protective concerns. So how is that, has that all been playing out?
Are you, this is on?
It is.
Yeah, you can hear me. So are you asking whether, like, are we checking to see whether there's an actual prescription for this medical marijuana? No, we are not. So we don't want to get into, we went down that road. We talked about it quite a lot in our committee. But we don't want to go down the road of testing whether parents have an actual order to administer marijuana, because all the different states have different cards or different processes, and we're in no position to validate or not validate. We don't know. We don't want to get in the middle of that, because if we challenge somebody on it, then they feel like they have to prove something to us that, again, we aren't in any position to evaluate really. So we've taken a stance that we're going to take them at their word. And unless it's clearly abusive, you know, like the dosages seem really out of this world or something, I don't believe that we would be raising a protective concern. So if the patient has a condition for which, a certifiable medical condition for which you might treat it with marijuana, and they happen to have the marijuana, we're going to accept that at face value. You want to add anything?
Yeah, I would just add that we want to, I think, and Kelly sort of touched on this, sort of create a situation of transparency in these situations. We don't want them bringing in brownies that we don't know have something in them because they don't want to tell us. We'd rather know and then have a thoughtful conversation with the family about whether this is in the best interest of the child if they've got one of these conditions, rather than have them be sneaking something in and not letting us know about it, because then we do run into the risk of over sedating or giving them something that interacts in a very bad way.
Any other questions? I'm just gonna check online to see if we
I just on the other point of whether, I think the question was if the Department of Justice subpoenas a medical record to prove that an immigrant has been abusing marijuana. Was that the question that you were answering?
Well, it was, can those medical records be used? I don't think they would be able to do that. I mean,
Yeah, those kind of requests are so rare, and like in all my time here, I've never seen anything like that. And so if medical records were to get a DOJ subpoena for a medical record, I'm sure they would contact me right away. And then if we had a concern that their medical records were going to be used against a patient, we would most likely elevate that to the Attorney General of Massachusetts to go to court for us or on our behalf, on behalf of the immigrant, and fight the subpoena, quash it. We haven't had it happen, but I think that would be what we would do.
yeah, and that, as far as the ability to subpoena, I mean, there I'm sure is a whole body of case law on HIPAA and Privacy Act and the need for them. I've never heard of medical records being subpoenaed in this sort of context for deportation proceedings.
Great. Any additional questions?
I'm getting questions by it.
I think there might be a question in the back. So, okay, I think we have another question up here, Rachel.
So there's a question about parental use of marijuana and its intersection with protective concerns, not medical marijuana, but recreational marijuana, and how, given that recreational marijuana is now legal, if there's, I'm sure there's been a lot of consideration for that, so.
Right, well, we've actually run into that a lot even before any of these questions came up around the legalization of it. So any impaired parent is not allowed on the property. And nobody's allowed to have aerosolized marijuana or smoke marijuana on the property. If you have a family member who's obviously impaired, so they've had edibles, so you can't smell anything, but they look impaired, you would raise that to them, confront them with it, and get them help if they need help, like take them down to the ED for evaluation if they need that. If they don't need that, just keep in mind that impaired parents shouldn't be making any medical decisions at all. And you might need to think about, if you have a medical decision to be made that's right then and there, and they're here because their child is sick, but now they're impaired, you may have a protective concern, and you would contact the child protection team to kind of walk through the analysis of whether you need to make a filing.
I see a question in the back.
I don't know a whole lot about how this is rolled out in other states, and I'm wondering if there have been instances where parents or adult patients, not an issue here, have sued their hospital for refusing treatment because it's legal, or whether that's like not an issue that has come up.
I don't know of any cases, but a lawsuit wouldn't get very far on those grounds, because if say we were sued for that, we just move it to federal court, and they can't sue us for following the law. It would die on the vine.
Okay, last call for questions. Oh, one over here.
I have a two-part kind of question on two different things. One thing that comes to mind is the hospital going to guide the nurses on how to document for the home supply? Because I know in home care that became a major legal issue. How, if I report to one of my RNs at home, my child's day, how they report, mom's report, is actually, there are good and bad ways to do it. That's the first piece. And then the other piece is, are there any federal loopholes for families who have children that are end stage? There is no hope. Physicians feel a cannabis product would be, something that could give relief. Are there federal loopholes in any of this? Or is it just, black and white?
So I can answer the first question. So in terms of documenting the home supply, so on a very granular and operational level, it's an order by the prescriber. So it puts an entry onto the medication administration record for the nurse to document. And so it puts charting tasks on the MAR that would allow the nurse at intervals to document the marijuana use. And that's what we have instructed them to do. So we sent out a module for nursing staff through NetLearning that's explained how to do that. We also brought it through our nursing pharmacy committee and our pharmacy and therapeutics committee to get approval and review by them. So that's the sort of operational way they would do it.
And the second part of your question, the answer is no. So the only entity that can change the classification of the Schedule 1s is the DEA, and they have declined to do so over and over and over again. So as long as it remains a Schedule 1, then no provider who can prescribe it. It's just those things on that list can never be prescribed. The federal government doesn't see any carve out for compassionate use, for any use whatsoever. And in fact, if you were ever charged say a provider prescribed it and then got dinged for it, in your trial, you can't even raise the word medical marijuana. It's just marijuana, and they just won't hear the medical piece of it. So, unfortunately, in answer to your question right now, no.
And now we have a question in the back.
Good morning. I'm aware, as I'm sure many people are here, that there is an ethics committee here at this hospital. I'm interested to know what is the ethics committee's opinion on this and how much have they contributed to this?
Unfortunately, we can't answer that. We don't have a member of the ethics committee here that I know of. If you're here, raise your hand. Yeah, I can't answer that. We've analyzed it from pretty much strictly from a legal perspective, because the stakes are so high for the hospital and for the providers, in terms of possibly being prosecuted. And we have also weighed the interests of the children who get these products, and we've created a way for them to continue to get them, but with us keeping our hands as clean as possible so that our providers in the hospital can't get in trouble with the federal government.
Any final questions? Okay, before we leave, just 2 quick points. One, thank you to our panelists, and a big round of applause for them for taking their time out. Thank you to the folks online and to those in the room. The Office of Government Relations has been monitoring the progression of this from a policy standpoint since the question passed last year. If you have questions, you can definitely reach out to us. We're happy to connect you to our panelists. We continue to have expert testimony at the Cannabis Control Commission, and we're deeply involved in that process. So if you have questions, definitely reach out. Please fill out the evaluations on your seats. All of these programs that we do are driven by you and the topics you care most about. If you have a topic selection and what you'd like to see next, please write it at the bottom. If you have any questions, I'll be sticking around for a couple of minutes, and thank you so much for our great breakfast on benefits in the first one of 2018. Thank you so much, and thanks to the folks online.